Dear friends, we have been deliberating the development, inception, and the entire historical retrospect of evolutionary process of international refugee law and protections thereunder, which are available to refugees. We have been able to visit in the international law context different stages of this entire evolutionary process of the legal institutional framework designed for the protection of refugees, not only in Europe, but beyond Europe. Today, as the last leg of my submissions, in the context of week 1, formally, however, informally speaking, in the subsequent deliberations presented, incorporated in different weeks ahead, many important aspects which have been deliberated, placed under the umbrella of week 1 are going to be taken up. And these observations, dynamics, and their delineation is going to be a perennial trajectory of our engagement in the subsequent weeks. Therefore, today I propose, let us have what has been the developments at regional level as a part of the historical retrospect, as a part of development, as a part of the growth of the idea of protection designed exclusively for refugees in the regional what you call context. My dear friends, there is no dearth of regional instruments. Let us begin with Africa. You will find a growing number of refugees fleeing wars and internal conflicts in Africa. Starting in the late 50s, which ultimately led to the adoption what is generally considered the most comprehensive and significant regional treaty designed exclusively to deal with the refugee problems in this continent. Organization of African Unity on 10th of September in 1969 adopted the OAU Convention governing the specific aspects of refugee problems in Africa. The primary importance of this convention, OAU Convention, is its expanded definition of the term refugee. That is the most beautiful aspect of this particular instrument designed exclusively to protect, promote, and safeguard the interest of refugees and ensure the physical, psychological, and mental protection of refugees. My dear friends, African states have felt that the well-founded fear of persecution was not sufficiently while a criteria to cover all refugee situations in Africa. Though in the subsequent week, when I am going to take up the definition aspect of refugee, who is a refugee, under 1951 conventions relating to the status of refugees, there is an expression within inverted commas, my dear friends, under Article 1 of 1951 Refugee Convention, and that expression, that ingredient as a part of the definition of a refugee is well-founded fear of being persecuted. So the word well-founded fear of persecution has not appropriately, adequately, sufficiently incorporated as a criteria, my dear friends, in at the regional level when we are talking of the definition of refugee in African context. If you take into account, my dear friends, the second paragraph of Article 1 of the African what you call convention, you will find that Article 1 of the African Convention provides the term refugee, and its application has also been ensured under what circumstances and what situations must be covered under this article. Number of paragraphs, number of what you call situations have also been what you call contemplated under this particular definition. It says that the term refugee shall also apply or will also apply to every person who, owing to external aggression, occupation, foreign domination, events seriously disturbing public order in either part or the whole of his country or her country of origin or nationality, is compelled to leave his place of habitual residence in order to seek refuge in another what you call place outside the country of origin or nationality. That is the most fundamental and basic premise that has been contemplated under Article 1 of this regional instrument, which is popularly known as OAU Convention, governing the specific aspects of the problems of refugees in Africa. So if you take into account the grounds which have been provided under this particular definition clause of 1969 OAU Convention, and how it is likely to be compared with the 1951 UN Convention relating to the status of refugees at international level, then you will find the grounds which have been enumerated in this particular definition clause and the grounds which have been envisioned in 1951 convention creates some kind of a dichotomy, dilemma, and some kind of a juridical ambivalence. If we go by the literal interpretation. But there is a need, my dear friends, the need for the harmonious construction of the legislative language of the two important instruments. We should not have any kind of a literal interpretation, because as I have already submitted for your consideration, that there has always been a requirement for the element of complementarity that must be reflected upon. That must also be the basis of any kind of a juridical implementation, juridical construction of language and judicial interpretation. At the time of adjudication, we must adhere to this particular element of complementarity. In other words, we can put it like this, that whenever there is any kind of confusion or any kind of an intellectual compunction before the judicial minds, it shall be under all circumstances be the responsibility of the stakeholders that they must invoke the idea of complementarity. The idea of complementarity has been further strengthened by adopting in 2016 New York Declaration, where under two important compacts have also been envisioned in 2018, which are today known as Global Compact on Refugees and Global Compact on Migrants. So therefore, it should be our sole responsibility, and these two important compacts as a non-binding framework for the protection of refugees are basically strengthening 1951 Convention at international level, and at the same time, these two global compacts have also given some kind of a wider choice to the national governments, that whatever may be the modus operandi of the national governments likely to be adopted for ensuring the protection for the refugees, they are within their own sovereign rights. These global compacts did not contemplate any kind of a binding obligations on the international nation states. Rather, it is the responsibility that has been contemplated voluntarily, if they are willing to extend their support. So because the idea of global solidarity, or the solidarity with the refugee hosting states, and available out of the available resources, that has been contemplated. And that is why that ultimately paved the way that majority of the nation states at international level have acceded to the mandate of these global compacts, and there are as many as more than 180 what we call signatories to these global compacts, and they have already started implementing the mandate under these two global compacts. I would also be what we call deliberating what exactly is the mandate, what is the institutional framework or sub-institutional framework, what is the intra-fragmentational approach that has been adopted in terms of the refugee protection under these global compacts, because one exclusive week is available, and that has been devoted to the idea of what we call how to ensure protection for the refugees. So what is important is that this definition is having a new categorizations of grounds, and these grounds have also been what we call contemplated. So therefore, we find 5 important grounds have been enumerated in 1951 UN Convention on Refugees. So far, Article 1 as a definition clause is concerned. And if you take into account the 1969 OAU Convention governing the specific aspects of refugees in Africa, it is also having number of what we call grounds, like for external aggression, occupation, foreign domination, or massive violations of human rights, or seriously disturbing what we call events or the public order in various parts, or some of the parts in the country of what we call origin, including what we call nationality, or the circumstances have been generated where the continuous habitation in a dignified manner becomes a hurdle. So in these kinds of situations, so it is very, very important, my dear friends, because OAU convention complements rather than duplicates the 1951 convention. Apart from the broad refugee definition, my dear friends, the OAU convention primarily regulates the question of asylum, if you take into account Article 2nd of 1969 regional arrangements. It also contains, my dear friends, the 1969 convention also contains important provisions relating to voluntary repatriation. It has been provided under Article 5th, and on the prohibition of subservice, or subversive activities by refugees under Article what we call 3, that should also be taken into consideration. So adequate what we call provisions are there under this particular convention. I would be making a detailed submission on this particular aspect in the subsequent week, which is exclusively devoted to the regional understandings and the regional framework for the protection of refugees. Now I take you to another important what we call understanding, which is available in the context of what we call of Europe, and how European framework has dealt with the problems of refugees. My dear friends, as I have already submitted that primarily 1951 UN Convention relating to the status of refugees have been designed for the protection of European refugees. But it is equally important at this stage to understand the dynamics of 1951 convention and how this particular convention and the subsequent what we call arrangements have been made for protecting refugees in Europe. Council of Europe has adopted several instruments concerning refugees, and some of the important what we call arrangements which have been adopted under the auspices of the Council of Europe, I can mention them. And these are the instruments which have been adopted in post 1951 what we call convention, which was primarily designed for protecting refugees in Europe. For example, European Agreement on the Abolition of Visas for Refugees. This arrangement, my dear friends, was adopted in 1959. Resolution 14 of 1967 on asylum to persons in danger of what we call persecution. This resolution was also adopted by the Council of Europe. Then European Agreement on Transfer of Responsibility for Refugees, that was also adopted under the auspices of the Council of Europe in 1980, I think. Again, there are certain important, my dear friends, recommendations on the harmonization of national procedures relating to asylum. These recommendations were also adopted in 1981, again under the auspices of the Council of Europe. Then further set of recommendations is also available, and recommendations particularly on the protection of persons satisfying the criteria in the Geneva Conventions who are not formally refugees. That was, these recommendations were also adopted in the year 1984. Then, my dear friends, Dublin Convention of 1990, which contemplated, my dear friends, a criteria for determining which member state is responsible for examining an asylum request when the applicant has filed an application for asylum with one or more than one of the states or another states within the what we call European community. And we should not forget, my dear friends, the European Convention on Extradition and Social Security. That particular convention also contemplates certain important provisions which are exclusively designed for the protection of refugees. So these are some of the many other subsequent arrangements have also been made. I would be making a presentation on those arrangements, particularly under week 7, where we are going to deal with how the regional arrangements have been functioning. If you take into account another important arena, and that arena is relating to the Latin America. Dear friends, in the context of Latin America, we find, as we claim in the context of South Asia, we also find a similar tradition in Latin American countries. Because asylum is not only a legal institutional framework in the modern days, asylum has developed and emerged as an independent discipline of research and investigation. Asylum has also established itself as the most solid specialization in the entire schematization of international law in the current scenario. Because it is the institution of asylum, my dear friends, that is highly abused institution today. In the name of asylum, all kinds of nuisance, all kinds of crimes against humanity, crimes against peace, crimes against humanitarian dignified survival on this beautiful planet, crimes against climate, all kinds of crimes are committed under the garb of institution of asylum. That is the reason we have been witnessing restrictions on the institution of asylum, and there is an emergence and emasculation of the institution of non-refoulement. We generally argue that the institution of asylum is a humanitarian institution. Institution of asylum is a human rights institution. Institution of asylum is an institution of peace. Institution of asylum is an institution that has been designed to maintain dignified and peaceful international relations. Institution of asylum conveys and determines the contours of foreign policy or policies of many geopolitical entities. Institution of asylum is a language of human right, a language of peace, a language of harmony. That is the what we call general understanding regarding this particular institution, and that is why we are under an obligation to promote this particular institution. Countries like Canada, countries like United States of America, countries like Australia, countries like India in South Asia, my dear friends, these are the countries, and you can also count another set of countries like France, Germany, and UK. These are the countries who have always, in their initial what we call days, they welcomed diaspora population. And we find that these nation states ultimately understood their demographies by inviting, by welcoming people who are fleeing persecution from different corners of the world. And that is why the institution of asylum has attained an added what we call importance. The institution of asylum is not only a diplomatic institution, not only the part of what we call of international relations, but our respective religions have also welcomed this particular institution of asylum. As I have already submitted on the first what we call engagement in this class of international refugee law, that there have been the institution of Ijara, institution of Aman or Aman, institution of Vasudeva Kutumbakam, institution of sanctuary in Christianity, institution of what we call of Dharmashala,
Sir,
and important what we call institutions. These institutions have ultimately enriched. So in the context of Latin American nation states as well, my dear friends, Latin American nation states have also been impregnated with the idea of what we call of institution
sir,
of. Yes.
Sir, can you be a little louder?
I am very much louder. This
No,
entire hall
perhaps
sitting
you
right.
can use headphones. It's your voice is coming low.
Am I audible now?
You are audible, but the voice is little low. Can you use headphones or something?
No, I can't use. I've got problem in my ears. I have been advised by medically that I should not go for headphones. Sorry.
Yes, you are audible, sir, and you are louder too.
Okay, thank you, ma'am. Thank you. Because you know my energy level, how I have been from the day when speaking. Even doctors have advised me that I should, keep the decibel of sound at the lowest stage. Otherwise, I am going to develop problems in my, throat. So I can share the video with all of you. No issues. I am having the perfect recording. So subsequently, whenever I get this video from the Google platform, I will share the entire recording with all of you. So what exactly I was, submitting? Can you tell me where I was? What was the point which I was, submitting? I have forgotten. Anybody?
Sir, Vasudeva Kutumbakam, you're talking about.
Pardon?
Just a second.
Yeah, I recall. Thank you. Yeah, Miss Pernil, I think you have left in protest. It's all right. Is there any problem with anybody else?
No, sir. We can hear you.
Yeah. Thank you, brother. Thank you. Thanks a lot. So, there are certain important regions in the global south. Including the Latin American nation states. And these Latin American nation states also maintained a historical tradition of welcoming people who are fleeing persecution, any sort of persecution without any kind of application of definition. It has always been there. Under all circumstances, we, the people of India, in South Asia as a nation state, always, welcome the people who are coming from different nook and corners of the world. Same has been the case with that of the, Latin American nation states. That is why I can say that Latin America has a long tradition of asylum. If you take into account, my dear friends, the Montevideo Treaty on International Criminal Law, that was, signed in 1889, was the first, regional instrument which ultimately dealt with the issue of asylum. This Montevideo Treaty on International Criminal Law was also subsequently followed by the Caracas Convention on Territorial Asylum in 1954. And there were many other, international as well as the regional instruments on the issue of asylum. In 1980s, my dear friends, the outbreak of the civil strife in Central America ultimately resulted in massive exoduses of close to 1 million persons. And these exoduses, my dear friends, have presented serious economic and social problems for the countries towards which this massive flow was ultimately directed. And this massive, what you call, movement of people seeking or in quest for the protection from the persecution in their respective, what you call, countries of origin, it resulted in another important, dimension which we find in the context of the Latin American commitments with regard to the institution of asylum. Therefore, in 1984, Latin American host countries adopted the Cartagena Declaration on Refugees. I am using the word declaration, though you are already well acquainted that there is a definition with this kind of a arrangements which is known as Cartagena Declaration. Pronunciation may differ because many pronunciations are generally, as many as 3 pronunciations are attributed to the word Cartagena. So in 1984, this declaration in the context of the Latin American nation states was adopted. This was the declaration which ultimately contemplated the legal foundations for the treatment of the Central American refugees, including the principle of non-refoulement, including the importance of the integrating refugees and undertaking efforts to eradicate the causes of the refugee problem. It was the most important commitment in global South, particularly Latin American countries, portion of the global South. We find a complete, what we call, unfettered commitment to the rights of the refugees. My dear friends, despite being a declaration, this particular arrangement in Latin American countries was very sufficiently, very appropriately, and very, very proactively reflected in the national policies and national legislations in Latin American countries designed exclusively for the protection of refugees. That was the beauty. We find novel provisions in the constitutions of these nation states. Not only in the area of refugee protection, but in other areas as well, including the what we call environmental protection or the protection of environment or climate change. We find various what we call specific dedicated constitutional provisions. Therefore, Latin American countries has ultimately celebrated the adoption of this particular declaration in 1984 called Cartagena Declaration. On the other hand, my dear friends, American states, and in some cases has been, these, states have incorporated the mandate of Cartagena Declaration in the national legislative exercises. Definition of refugee in the declaration or Cartagena Declaration, my dear friends, is similar to that of the OAU Convention. But it includes, and again, there is a requirement to have some kind of a complementarity element. Because if you go through the definition clause of the Cartagena Declaration, you will find that this declaration, my dear friends, includes as a refugees, and refugees are those persons who have fled their country because their lives, safety, integrity, freedom have been threatened by generalized violence or massive violence or foreign aggression, internal conflicts, massive violations of fundamental civil liberties, or other what we call circumstances which have seriously disturbed what we call a dignified existence of the human beings or disturbed what we call public order. something like this. So these are the grounds. So I'm not able to reproduce the exact what we call language with precision and exactitude. So therefore, you should read this particular Cartagena Declaration in its totality. Even if you are not going to study refugee law, even then as a part of the international human rights law, as a part of a lawyer, this is our fundamental duty, not responsibility, that we must be aware of these kinds of arrangements, because now we have been witnessing in the third decade of the 21st century, my dear friends. As a lawyer, at any moment we can confront with any kind of what we call question relating to the safeguards and guarantees which are available to the refugees. Therefore, the Cartagena Declaration is not binding on states. Even then, majority of the nation's states have incorporated the declarations provisions in the national legislations. However, it is applied in practice by a number of Latin American nation states, even in the absence of their national what we call incorporation of these provisions. Another important dimension that comes to my mind is international human rights instruments for refugees. International human rights instruments, when I am saying, though the refugee specific provisions have not been dealt with adequately in the third semester, because these are the provisions which should have been, or at that point of a time when I was engaging you in the third semester on international human rights law, I was of the view that some of the refugee specific provisions have to be taken up for our understanding in the fourth semester. And that is why, my dear friends, I am of the view that we should also study in so far the international human rights instruments are concerned. And 1 week we are having on internal displacement, another important aspects where the international human rights regime definitely coming for our engagement, and we are going to engage a lot of what we call provisions, particularly 1966 International Covenant on the Elimination of All Forms of Racial Discrimination, 1966 International Covenant or UN Covenant on Civil and Political Rights. Again, 1966 UN Covenant on Social, Economic and Cultural Rights. 1984 Convention Against Torture and Other Cruel, Inhuman what we call or degrading treatment or punishment. That is popularly known as the Torture Convention of 1984. Apart from or in addition to these international human rights instruments where we find specific provisions for the protection of refugees, there are other international instruments which should also be taken care of whenever we are dealing with the problems of refugees, because other conventions and declarations, and some of which we should have in our what we call faculty of understandings at every moment whenever we are confronted with the question of refugee protection. For example, 1949 Fourth Geneva Conventions relative to the protection of civilians or civilian persons in time of war. We should be very careful of this Fourth Geneva Convention, particularly Article 44. Article 44 of the Fourth Geneva Convention, whose aim is to provide protection of to civilian what we call victims. And this particular convention, particularly this article 44, deals with the refugees and displaced persons. So specific what we call articles are there. Then we should not forget, my dear friends, Article 73, and this should be on your fingertips. That is why I am emphasizing, and this is my humble submission to all of you, please do not forget, and you should what you call expand your horizons. You should not feel that it is basically the 1951 UN Convention with its additional protocol of 1967 relating to the status of refugees. We should not what we call, deceive our, juridical faculty of understanding that these are the only two important instruments which constitute the subject matter of international refugee law. It is going to be a preposterous proposition. It is going to be a fallacious argument. And it is going to be a fallible understanding. Yes, of course, a refugee-specific instruments is there in public domain, and some of the provisions of these, refugee-specific instruments have also attained the status of just cogence and have become the part of what we call the customary international law or in customary international law. But in addition to all these, arrangements, there are umpteen number of what we call of instruments hailing from different what we call, branches of international law. Though I am calling for the sake of understanding branches, otherwise these branches today have become independent disciplines for specialization on research. So therefore, Article 73, my dear friends, of 1977 additional protocol to the 4 Geneva Conventions of 1949. Article 73 contemplates, envisaged that refugees and stateless persons shall be protected, what we call, persons under paragraph 1 as well as the paragraph what we call of 3rd of the 4th Geneva Convention. This is the arrangement. Another important what we call, convention is also there. I have already mentioned this convention, and that is the 1954 United Nations Convention on the status of stateless, persons. Under this particular, arrangement, Article 1 of 1954 Convention defines stateless persons as a person who is not at all considered as a national by any state under the operation of its what we call, law. It further, prescribes, my dear friends, the standards of what we call, treatment, and these, treatments must be meted out to the stateless persons. Again, there is another important, convention. Again, let me remind you, I have already mentioned in my, second submissions to all of you, and that is relating to the reduction of the, stateless, what we call, person. Another important, arrangement is also there, and that arrangement, despite the fact we are not having these, institutions anymore in existence or in operation, but the mandate of what we call the work that has been administered, the other important, facets which are, there are still relevant. For example, the work of the League of Nations in 1921, my dear friends, that ultimately helped persons in danger, and it has ensured their safe return to their homeland. United Nations organizations has established, as I have already told you, it has established United Nations High Commissioner for Refugees in 1950. Convention was also adopted in the subsequent year, the very next year, that is in 1951. Then we also got a definition for the stability of our, understanding, juridical understanding, as well as the legal understanding, how to deal with the problems of refugees and ensure their respective what we call protections. UN definition has also been what we call there in the public domain, and we have to understand in the subsequent what we call weeks the different ingredients of the definition. Then we are also having other important what we call arrangements, and these arrangements must also be taken care of. But whatever the deliberations we have undertaken as of now, My dear friends, it is equally important to understand the different what you call segments of the migration, because it is equally important in the current circumstances who is a refugee and who is a migrant. If you try to understand or try to draw some kind of a distinction, you will find the distinction between refugee and economic migrant. At the beginning, at the very threshold of my submissions, when I was dealing with terms and terminologies, I explained it. But it is equally important at this stage as well. My dear friends, behind economic measures affecting a person's livelihood, there may be racial, religious, political aims or intentions directed against a particular group. We have been witnessing in many geopolitical entities, because of the emergence of the majoritarian narrative, because of the emergence of a predatory nationalism, which is known as the popular nationalism, because of the emergence or resurgent what we call othering of some of the communities in geopolitical entities, we have been what we call witnessing new set of economic measures currently are being advocated. So where economic measures destroy the economic existence of a particular section of the population, in such situations, we find a new kind of a migration, which is known as, my dear friends, as economic migration. And the people who are undertaking this kind of a migrations, they are generally known as economic migrants, because it is a involuntary economic migration. And there are voluntary economic migration as well. My dear friends, as per the some of the reports which have been submitted by the International Organization for Migration, as many as more than 100 countries classified as having major inward or outward population movement. United States of America and Europe, they have already spent more than 10 billion on asylum management annually. Many have between 10 to what we call 40 million illegal immigrants at their borders. So therefore it becomes necessary to distinguish who is an economic migrant and who is a refugee, because financial implications are there, humanitarian implications are there, political implications are also there, and these ramifications constitute a heavy burden on the national resources of many geopolitical entities. Increasingly difficult, my dear friends, as reasons for flight are multifactorial, I should say, because in this kind of a migration, what we have been witnessing pull and push factors. We also witness the evidence of persecution in majority of the situations may not be available. Everything is not at all what we call in the world of refugee movement. Everything is not possible to be what we call, to witness each and everything. Because there are, certain important rights of refugees, which I have, deliberated. And very soon I am going to share that research paper. That is going to be published by Springer. I will share that very research paper of mine, where I have, listed certain important rights of refugees which have not been mentioned in international human rights instruments or 1951 UN conventions relating to the status of refugees, including its 1967 additional protocol. We do not find these rights. Because we cannot make any kind of a presentation of the evidence with regard to the violations of certain specific rights, which have not been there as a part of what we call of these instruments. But there are, rights. Suppose, as a student of law, if I am, attending your grievances, your concerns, despite the fact there are certain important institutional norms, rules, and regulations, whereunder certain institutional duties and obligations have been ensured on my part. And under these, institutional obligations, student community has been empowered to enjoy a right which I call a right to have a sense of trust between students and teachers. Though the right to have or right to a sense of, trust has not been mentioned anywhere. Because evidence of this kind of a right cannot be, it is your right, but at the same time, it is my duty towards you. But we cannot produce any kind of an evidence of this kind of a right. I can't produce an evidence that this is something which I have ensured, and you cannot what we call, produce any evidence that it has been violated. So there are certain important rights which can only be felt, which can only be, felt in an abstract manner, intrinsically as well as extrinsically. So these rights constitute a very abstract, what we call, notion of understanding. Therefore, when we try to make a distinction between a refugee and the economic migrant, then we should not forget there are push and pull factors. Because in the context of industrialized nation states, we can produce the evidences of the generalized violence, breakdown of the civil order, and we can also what you call produce evidences of the what we call of the internal conflict in a geopolitical entity. And that is the reason that the United Nations, it is generally alleged that the United Nations Convention on Refugee Mandate does not address or does not cover a specific group of people like criminals. Criminal elements are not being or have not been covered. Subversive elements, hostages, victims of the natural disasters, And that is the biggest, what you call, protection gap that has not been, what you call, addressed by 1951 UN Convention relating to the status of refugees. But there is only one paragraph in a normative sense of understanding that has been provided as a guideline. In 1998 UN guidelines on internal displacement, but at regional level we got a full-fledged, what we call, convention, which is popularly known as African Convention on Internal Displacement, that was adopted under the auspices of the African Union in 2009 at Kampala, the capital city of Uganda. So there we have adopted this particular convention, and it is having the full-fledged, what we call, mandate in Africa how to deal with the problems of internal displacement, or the people who are internally displaced, popularly known as, in the abbreviated form, as IDPs, internally displaced persons. So unfortunately, 1951 convention relating to the status of refugees, my dear friends, that does not cover disaster displacement. To a limited extent, we find some guarantees in terms of damages and reparations under the United Nations Framework Convention on Climate Change of 1992, UNFCCC. And some other important COPS commitments have also been there, including the latest one, which was there at Sharm el-Sheikh. But the biggest, what you call, commitment remains to be implemented, that was adopted as the Paris Agreement in 2015. So therefore, the disaster refugees are also there. Two kinds of refugees we have been, broadly speaking, we find there in the public domain. One is a disaster, what we call, displacement, and another one is the conflict, what we call, displacement. Disaster induced displacement, as I call it, DID, did, and the conflict, what we call, induced displacement, CID, SIT. So these two kinds of, broadly speaking, we are having displacements. But when there is a question of refugees, or who is a refugee and who is an economic migrant, then the 1951 convention does not again address economic migrants, because economic migrants fleeing economic privation or economic persecution has not been dealt with under the Islamatization of the 1951 convention. And that is why some of the scholars are of the view that the economic migrants or economic persecuted, individuals should be known as eco-refugees. But in my, what we call, understanding, I do not concur with these kinds of, nomenclatures. On other occasion, I will come out with my own understandings of economic refugees. Now the question arises at this stage: who looks after refugees? My dear friends, why I am raising this question? Because in a detailed manner, I would be, answering this question in the week 5. Under week 5, we are going to deal with the problems how to determine the status of refugees, which is known as a Refugee Status Determination Procedure, RSD procedure. And there is a manual of guidelines in the form of the handbook on RSD that was prepared by the United Nations High Commission for Refugees in 1979. We would also be coming to that particular aspect under week 5. But initially at this stage, because we have to, under week 1, we should be able to understand at least the normative, what we call, understanding must be developed under this particular, week, and we should be able to encompass, encapsulate, and apply our understanding to the rest of the weeks. So, who looks after refugees? If somebody asks you, what kind of a mandate is available to the nation states? Whether in our individual capacity, my dear friends, we are able to address the problems of refugees. So how to answer, how to visit this question, who looks after refugees? Number one is state. My submission is, and the number one is the state, because the state is responsible for its own citizens. In the same manner, if the refugees have been welcomed, sheltered, received within our what we call backward or our front yard, we should extend the same kind of a treatment to them, with minor exceptions. So the primary responsibility of all the citizens of the world lie with their respective states and governments. Now there is a role of the host state, as I have already submitted. Host state particularly, my dear friends, there is a general understanding with regard to the nation states located in the global south, that these nation states have got very limited resources. They are not in a position to host massive population transfers and massive refugee exoduses. And therefore, it has been contemplated, my dear friends, the richer nation must host refugees. But it remains an irony, my dear friends. If you take the entire, refugee population on this beautiful planet, you would be surprised to know that more than 85% or 87% or in between these two, what we call, figures, around what we call, 86 plus percentage, refugee populations globally are being hosted by the global South nation states. Though primarily it appears in newspapers, in magazines, in webzines, social media, that majority of the refugees are currently being hosted and helped by the global North nation states. It's an infructuous argument. It's a vexatious, premise under international law. In reality, it is basically the global South nation states where you will find more than 76% of refugees. But there is no limelight. These kinds of, hosting of refugees is never what we call, highlighted. They are not hogging limelight. A small country like Bangladesh in South Asia, my dear friends, has been hosting since 2017 Rohingya refugees in the biggest or one of the biggest refugee camps that got erected and embedded in the vicinity or at Cox's Bazar, a border what we call city between Myanmar and Bangladesh. So you can very well understand what has been the destiny of refugees, and what has been the burden, the implications of this burden, what kind of a burden the government of Bangladesh has been entrusted with, without any kind of a, what we call resource generation. Economically, the government of Bangladesh is not at all what we call in a position to deal with this kind of a exodus of the Rohingya refugees, because of its limited resources, because of what you call of, poor economy, or I should go to the extent of, recording at this stage that the economy, a significant portion of the Bangladesh economy is tottering under the weight of Rohingya refugees. And unfortunately, in this entire what you call scenario, United Nations organization is not an implementing agency. On many occasions, that is why the people, including myself, have been contemplating what is the relevance of this kind of a body called United Nations organization. Are we heading to producing more refugees? Ever since the Russian Federation attacked, committed incursions into Ukraine, is it the beginning of the Third World War? It's a very, very relevant question. And again, we are going to produce more refugees. Because similarly, the same kind of a circumstance or identical circumstances we have generated. Every conflict, whether it is a conflict in our home, or whether there happens to be a conflict in our country, and whether a conflict is there in our region, or whether there is a conflict or violence at international level, it basically a very, very horrendous premise to understand. If you recall, my dear friends, how Second World War was started. It was an attack by Hitler in 1939 on Poland that basically germinated the seeds. It was the beginning of the Second World War. So should we presume that the Ukrainian, Russian Federation and Ukraine conflict is the beginning of the Third World War? Because today many of the nation states are not in a position to engage militarily in any part of the world, including what we call NATO armed forces. It is altogether a different story that they have been helping. Because even at that point of time, President Roosevelt of what we call of United States of America was not very keen to have any kind of a military engagement. But there has been some kind of a what we call catalyst. And the catalyst which ultimately what we call brought United States of America at the front of the military engagement, it was Japanese attack on the Pearl Harbor that impelled Roosevelt to go for military engagement. And unfortunately, before the dropping of the atom bomb on Nagasaki and Hiroshima, President Roosevelt died. And it was the Vice President Truman who ultimately led the United States of America into Second World War. That is the part of history. But what is important at this stage is, my dear friends, each and every conflict had produced a lot of refugees. Whether you call them the humanitarian crisis or the humanitarian refugees or the war refugees, but what is important is that it was basically the human sufferings, persecution. Persecution exclusively on the grounds of political opinion. Governments may be the enemies of each other, but the people of any geopolitical entity cannot be enemies. They are the simple civilians and simple human beings. They got nothing to do with their political bosses and political masters. If you as an ordinary citizen today visit any of the enemy countries, you will find that there is nothing, there is no hostility, no animosity among the general masses and general people. These are the national governments, because of their own vested what we call interests. They have been what we call fighting, and in between, what result has been the production and generation of refugees. That is why, my dear friends, it is the fundamental responsibility how to deal and how to what we call look after refugees. Therefore, there are many non-governmental organizations as well who are implementing partners of the United Nations organizations, particularly the subsidiary organizations of the United Nations organizations, that is UNHCR, United Nations High Commissioner for Refugees, and other important what we call partners like the CRS, like what we call CARE, like what we call IRC, ICRC, MSF, number of what we call and many other important what we call members of the Red Cross. So members of the Red Cross movement have ultimately contributed a lot at the national level as well as at the international level, International Federation of the Red Cross. That has also, another important, agency which is also having the similar and identical, mandate and engagement, which is known as the Crescent Societies, that also, coordinates and coordinated on many occasions with all the, national, societies, International Committee of Red Cross. Generally, assists the wounded in conflict, what we call, situations. But what happens to refugees with all these kinds of what we call of engagements in the name of what we call health, in the name of humanitarian assistance, in the name of what we call of all kinds of assistance which is rendered by these non-governmental organizations? Then what happens to refugees? Number one, repatriation. Number two, return to repatriation means the return to the what we call to their country of origin, or the country of or to their homeland or country of nationality. Then they must be what we call preceded by the political change. Whenever there happens to be a change of God in the country of what we call of origin, they feel a sense of what we call of normalcy, and generally they return to their country of origin. Then integration. It has been less common, my dear friends, when we are talking of the integration, because integration poses a lot of questions. When we are talking, if somebody has migrated from India or from Germany or from Afghanistan to Germany, a Afghan who is willing to have some kind of an integration in his new country called Germany, then there are certain important problems. Problems of problem of language, problem of culture, problem of what we call of traditions, and other important what we call problems, which cannot be enumerated. That is why, in case of in the context of the Syrian refugees or Syrian refugee crisis, when they have started migrating from Syria in 2015 in the month of March, and they were given shelter in some of the European nation states, particularly in Germany, Belgium, and France. Then during those days, special language tutorials were also arranged by the national governments for their smooth integration. Remedial classes have also been what we call started. These steps constitute the very first what we call stage of any kind of reintegration or integration. Another important remedy which is available to refugees is resettlement. Resettlement, my dear friends, in a third country. And resettlement, my dear friends, during the Cold War, if I am correct, that was not a remedy at that point of a time. It was not a remedy. many options were not available to the refugees during this particular period of Cold War, when the people started migrating from different parts of the world. Because of their political opinion, people were migrating. Entire world was during Cold War was divided into two important political blocks at international level. One was led by USSR at that point of time, former USSR, I should say, a communist bloc or communism. Another one was the capital, what he called, bloc or the capitalist, countries led by United States of America. Somewhere in between, the organizations which were not in a position to build any kind of a political or diplomatic clout during Cold War was organizations like non-alignment movement, led by what he called, Pandit Jawaharlal Nehru, Marshal Tito, and Colonel Nasir. So they were not in a position to build any kind of a diplomatic, clout. Despite the persons of these kinds of, organizations like non-alignment movement, in reality, the world was, divided between the two blocks. Now, in today's, circumstances, we are witnessing the production as well as the generation of more refugees in a world which is what we call, diametrically and diagonally divided. We are having a truncated world order. We are having a policy of non-alignment movement that is no more relevant. Rather, this policy of the non-alignment movement was replaced by the multi-alignment movement. It has become the, one of the most important feature of the foreign policy, what we call, of many geopolitical entities, including South Asian nation states, and prominently among them happens to be India. It has been very much at the forefront to argue and to espouse this kind of a, foreign policy exclusively based on multi-alignment. So in an age of multilateralism, we are not able to curb the generation of refugees. Despite the fact we are having the idea of durable solutions, which I have already explained to you, which is consisting of a trinity of solutions: voluntary repatriation, integration, and resettlement, which ultimately necessitated, my dear friends, and it was realized by the Barack Obama administration, that the political angle of the refugee problem should not be diluted, and it is no more possible to ignore this emerging dimension, which is very much humanitarian, at the same time it is political. And that is why, at the complete what we call engagement and collaboration between the political outfits led by United States of America under Obama administration on one side, and it was the UNHCR on the other side, the political characteristics of the refugee problem was ultimately acknowledged, realized, and critically appreciated, and which is reflected in the adoption of 2016 New York Declaration on Refugees and Migrants. Under this, watershed development in the history of refugee protection, on 18th and 19th of December in 2018, at Marrakesh, two important compacts, as I have already submitted, were adopted by the international community of nation states under the auspices of the United Nations Organization, which ultimately established how to deal with the problems of refugees without entailing financial implications and legal implications or legal ramifications. And that is the reason, my dear friends, we have been hosting, we means majority of the nation states have been hosting refugees. But there is another important question that comes to my mind: what are the consequences of international migration? How to deal with this kind of a question in the current scenario? As I have already told you that the institution of asylum has become highly controversial. It has become highly abused. It is a convoluted, repulsive premise, and majority of the nation states have become paranoid, xenophobic, and hostile to this particular institution, the institution of asylum. In current scenario, my dear friends, whatever may be or whatever must have been the history of institution of asylum, even during the pre-socio political understandings of humanity and human concerns. But if we take into account the current scenario of asylum has become very difficult. Because in current scenario, the people who have been seeking asylum with the legitimate claims in a majority of the situations have been rejected by various geopolitical entities. In majority of the situations where the asylum very legitimately and conclusively have been claimed, these applicants, asylees or asylum seekers, have been rejected, returned to the transit countries. On the earlier occasions, I have shared an example from Australia. Australia has been very notorious in terms of what we call of providing asylum. And that is why the majority of the nation states have been what we call seeking new approaches towards asylum management or migration management. They have been what we call redebating. They have been what we call coming out with a new kind of a vision on visa, what we call requirements, interdiction at sea, as well as what we call fast track procedures, accelerated what we call procedures designed for the asylum applications. Refugee numbers have been increasing, and the dream of a refugee-free world remains unattainable. And I don't see in near future, my dear friends, that we can achieve a utopian what we call world called a refugee-free world. No. Refugee movement and migration has become coterminous with the existence of this beautiful planet. And it has become one of the most important argument that refugees don't want to be counted. Host governments don't want international attention to internal problems. International humanitarian community or humanitarian community at international level is not at all interested, my dear friends. International humanitarian community don't want to intervene in the matters of refugee generation, refugee hosting, and other what we call internally or internal migrations, or the people who are moving from one part or to the another part in the same country. And it has almost become very, very difficult, my dear friends, to assist without what you call any kind of a denominator, since cannot make what you call any kind of a estimation so far the aid and advice and financial assistance to refugees is concerned. So there has to be some kind of a final, I should say, underlying principle. The final underlying principles that comes to my mind is that everything about refugee situation is political. That is my understanding. I do not see, in my understanding as a student of international refugee law, I do not see refugee problem as an humanitarian crisis. Yes, it is a humanitarian crisis, but at the initial stage. And it remains a humanitarian crisis for an ephemeral period. And that ephemerality is immediately what we call, replaced by the politicality. And it becomes a political, and that is why humanitarian crisis or humanitarian attribution is a very short-lived attribution, but the bigger or the biggest consequence of any kind of a refugee situation is political. It is basically the international geopolitics that determine origins, maintain, or any kind of a reception, maintenance, and the resolution of this kind of a crisis. This reminds me, my dear friends, of a very, very important observations that has been made by Professor Gaius Goodwin. And let me what you call read and try to understand. I will also email this particular observation of the Professor Gaius Goodwin, who is from the University of Oxford at its All Souls College, Professor Emeritus. And Professor Gaius Goodwin is of the view that over the past 2 years or so, Europe has been challenged, like many countries in the South, by what to do when faced with a large number of what we call refugees, asylum seekers, and migrants, many in desperate need of protection and assistance. True to form, some alarmists have raised the security what we call specter, as if enough terrorists were not homegrown or able anyway to use a regular what we call means of transport, forgetful of the extent to which states have already securitized the movement of people, certainly since the mid-90s, if not much earlier. Europe's failure, however, has not been on the security front. Rather, it has been, or it has so far failed to live up to its principles to make the best use of the existing mechanisms, institutions, and laws, and to think proactively outside the box so as to develop a regime of protection, asylum, and migration management fit for the 21st century, in which both the rights of individuals and commitments and the what we call interests of states can effectively be lawfully and equitably accommodated. So this is the statement, my dear friends, that has been given. So what we have been witnessing, my dear friends, one line of the Professor Gaius Goodwin that really repels me and disturbs me, I should say, and that is, my dear friend, the securitization of the institution of asylum. Because it has become a fashion to deny asylum among the nation states. And majority of the nation states are of the view that homeland security, sanctity of the sovereignty, sacrosanct character of the territorial integrity, threat of what we call global terrorism, these are some of the important premises. While taking into considerations the collectively, I mean cumulatively, these considerations into account, national governments are not hosting refugees, they are not able to provide. And there is only one narrative, my dear friends, cumulatively speaking, national security narrative versus human rights. How to make any kind of a reconciliation between the two, that has presented the biggest challenge. So in majority of the situations, my dear friends, the national governments are of the view that it is primarily the national security narrative that must be taken and given some kind of a approbation, political approbation, even in judicial proceedings. In the case of Samiullah Khan, that is a case relating to the Rohingya refugees' deportation from India to their country of origin. The government of India, while advocating and pleading their deportation to their country of origin, argued before the Honorable Supreme Court of India, and it has contended that there is a national security threat. If we do not what we call, there is a standing what we call threat, eminent threat. There is a permanent threat from the Rohingya refugees, some of the armed groups of the Rohingya refugees, if we further allow or continue with their stay in India. So there is a threat to the national security of India. So this national security narrative, my dear friends, that has also presented a lot of impediments. However, it is altogether a different story, my dear friends, that no credible evidences have been presented. Only an argument has been presented that there is a threat to the national security of India, but it has never been proved. Though there are some allegations, and there is some element of credibility in this allegation that was leveled by the government of Myanmar against Rohingya people, that they have also formed an armed group. But the allegations of the radicalization are some extent true in case of Syrian refugees in Europe. But in the context of what we call of the Rohingya refugees, no credible evidences have been found, and you can also correct me, my dear friends. Whatever the resources I have consulted as of now on this particular point, I did not come across with any of the credible evidences where there have been a purported involvement of Rohingya people in radicalization, number one, or any kind of subversive activities, particularly in case of India. Though many crimes have been reported in the Cox's Bazar, where the Rohingya refugees have been what we call found involved in crimes, what we call a crime of murder and rape within the what we call Cox's Bazar refugee camp. But we find a perennial cycle of securitization of asylum, institution of asylum, that is there, and it has become very difficult to make any kind of a distinction. We find restrictionism, securitization of asylum in Europe, as well as in United States of America, including Canada and many other parts of the world. So it has presented a lot of what we call, double standards so far the refugee protection is concerned. With these few important what we call, understandings, my dear friends, it is very, very important, my dear friends, that whatever may be the population of refugees currently at international level, it is basically the global south nation states who are at the forefront in hosting refugees. And there are new what we call, refugee movements, which are of late we are also emerging. Lebanese refugees, Jordanian refugees, Venezuelan refugees, Mexican, refugees, and many other important what we call, displacements, as well as the disaster displacements, because we would be, discussing disaster displacement under a week, which is, exclusively devoted to the climate refugees. I will also be dealing with those what we call, understandings. So in this kind of a situation, it becomes necessary to understand, my dear friends, how to what we call, understand refugee crisis. I am not going to data. If you go through the data of what we call of 2015, what has been the refugee population at global level, and compare the data which is available up to what we call December 2022. During these 7 years, what has been the exponential growth of the refugee population, and what has been the treatment of this kind of because in public domain you will find the entire documentation, and I am also bound to share the different what we call figures. My dear friends, it is immensely incongruous that in a country as large, wealthy, and multicultural as Australia, the treatment of asylum seekers and the refugees is a national what we call preoccupation. Initially, it has been the scenario. But my dear friends, the conversation is not about rights or responsibilities right now. Conversation is not about what we call any kind of humanitarian assistance or protection. Rather about what we call stopping the boats and smashing what we call people, smugglers, and the business models. Because the transfer of population of late has attained some kind of crisis proportions in case of what we call black refugees, Rohingya refugees, and other what we call Far Eastern, Middle Eastern what we call refugees. Now there are some important refugee crises, and majority of the nation states who claim themselves to be the civilized nation states, they have forgotten a particular class of refugees, and at the same time this particular class of refugees is the result of their policies. I am talking of, my dear friends, the Palestinian refugees. Therefore, in many countries, asylum seekers are an easy target for the anxieties about what we call national security, unemployment, and demographic what we call composition. Because the national government are of the view that our national resources are limited. We cannot allow any kind of a demographical change. We cannot allow the sovereignty and integrity and the political independence as a nation state, it should be compromised. People are not worried about the, about the balance between national security and human rights. Despite the fact that asylum seekers cannot vote. And that is the reason, my dear friends, the voices, the concerns, any sort of activism which is undertaken by the asylum seekers are generally marginalized, diluted, and they are silenced. Particularly in political debates. But there are, some countries like Germany, there is a new kind of a discourse which is emerging in Germany and United States of America. In United States of America, private families have given a new idea of sponsorship for refugees. In their private capacity and with the help of their private resources, they have been extending help to refugees and they are hosting refugees. In Germany, there are some refugee communities. Instead of becoming the liability on the state exchequer in Germany, these refugee groups have become an asset for the German government. They have been, contributing with their skills. I'm not going into the, nature of skills. But the German government is making the optimum utilizations of the services of the refugees. So this is how we can, ensure the integration of, refugees in our respective, territories. At the same time, my dear friends, if you take into account the political picture, politicians have ultimately failed. And they have also, fueled fears that asylum seekers present a threat not only to the integrity of the various geopolitical entities. Geopolitical entities like Austria, Spain, Italy, Australia, and many countries in South Asia, Southeast Asia. Politicians have aggravated the situation. They added salt to injury. They have done the biggest disservice to the cause of hosting refugees. But there are certain elements. In addition to this kind of a trajectory, there are certain elements of media. Media have not only fanned and fomented the flames, but poured some kind of a accelerant, which ultimately cleared the pitch for the refugee protection. And this is the situation we must contemplate. Because as a island nations or the landlocked country, we have been witnessing, and it is generally as many geopolitical entities have disproportionately suffered from invasions. But the refugees are not invaders. Many politicians have alleged that we can't allow our nation states as the refugee capital of the world. It is not a designating or making some of the cities as the refugee capitals. It is a question of humanity. And that is why there are certain important aspects to this particular, issue, the issue of refugee protection. And the issue is, my dear friend, that there is a provision for temporary protection. There is a provision to the flight alternative. So these alternatives must also be exhausted. And that is why I am talking that there is another important dimension to it. And that is a dimension, and that requires some kind of a, international, what you call, understandings. If we are really reluctant, really interested to make this particular, alternative a viable alternative for the realizations of the refugee protection. And that is a, right of the state to seek compensation from the refugee generating or refugee producing nation state. I will continue, my dear friends. If you have questions, you're most welcome. In the next week, we are going to meet offline in the classroom in the new campus. How many of you are, attending this online class from the new campus? Yes, ma'am. Yes, Ms. Kathir. Ms. Kathir, please unmute yourself. Mr. Ganesh. Yes, Ms. Kathir. You are there in the new campus.
Yes, sir.
Okay, good. And Mr. Ganesh, you are also there.
Yes, good afternoon.
Yeah. So how do you find hostel accommodation over there?
Yeah, it
Sir,
is good, sir.
we have got
Better than the Akbar Bhavan.
In terms of hostel facilities, it's better than Akbar Bhavan because it's spacious and we got the new washrooms and like everything is good. But in terms of transportation, like to get things outside, it's a bit hard. But now the rickshaw services is provided, so it's quite okay.
Okay. So what about the classrooms? What kind of classrooms are there?
Even classrooms also spacious, sir. Very big classrooms like halls.
Okay. Good. Yeah, anyway, thank you very much for being with me. Enjoy yourself and see you next week in the classrooms. So I would be there and I will attend. Right now, I am at my home. Yeah. Thank you very much. Take care. Bye-bye.
Sir. Good day.
Thank you, sir.
Thank you, ma'am. Thanks a lot.
Thank you, sir.
Thank you very much for your copy.
Thank you, sir.
Thank
So
you.
I have sent you a mail regarding my accident. I think hope you get
Yeah, that I got.
Yes,
That I got.
Pray for me. Sir.
Yeah,
you.
so please take care of your health. Otherwise,
Yes, sir.
everything is manageable, Mr. Naeem. So I would be, I am there to handle your health-related issues at all. Yeah. So please stay blessed and take care of your health. Yeah.
Yes,
Bye-bye.
sir. Pray for me, sir. Thank you so much, sir.
You're welcome.
Thank you.